to investigate or consider disqualification under the 14th Amendment. The Secretary of State herself explicitly said there's no explicit
And I don't think
authority.
they're arguing that in the duty part of the language. I think I understand them to be saying if the Secretary were to put President Trump's name on the primary ballot, that would be a wrongful act because the former president, is not qualified to be on the primary ballot. So it's not an argument of dereliction of duty, it's an argument about a wrongful act. And under Kuhn, they're arguing we can look at other evidence that she might not look at.
I think Frazier answers the other wrongful act and rejected that expansive interpretation. And specifically, Frazier said the problem with that is that there's no limiting principle. I say that because I made that argument, and it did not succeed. And I will be honest, I think it's proper looking, because in large part the Secretary of State said these expedited proceedings are wholly inappropriate for something beyond the election code because of the complexity of them and the incompatibility with this. And this is exactly, I think, what happened in this case, where we were denied all discovery, no initial disclosures, no opportunities for depositions, a limited time frame of 6 weeks to prepare our case from nuts to bolts to contend with 400 conclusions within the January 6th report, which became 100, which ultimately became 31. So there were a lot of infirmities in these procedures, and that was first and foremost, I would submit, in the Frazier Court's mind. Justice Gabriel, in his dissent, said, well, that can be and should be resolved with respect to a management order, a case management order in the trial court below. I think that optimism was probably misplaced, as proven by this particular case. So this was, in fact, in substance and in consequence, constitutional litigation. This was not a duty under the election code, which is what 113 requires. The reason why 113 has expedited procedures, the reason why they are appropriate and tolerated and endorsed in the election context is because they are generally simple, straightforward duties that don't involve complex constitutional litigation.
So is the rule that the Secretary has authority if it's simple and not complex, but doesn't if there is? I mean, it's hard to articulate a standard like that.
I think the standard is the constitutional standard. To be sure, a residency requirement like the type that was litigated in Kuhn can be complex. Not complex like this. It's like a constitution with the same things as the consequences of it.
Complicated is standard is.
Well, court equated it, but the
I heard your answer to Jared.
I'm sorry to interrupt before you go into the second, but the framers took a whole lot of the fact that the electors were going to bring insurrectionist former President Jefferson Davis.
yes, and 100 years. It wasn't 100 years until a Southerner got elected. Now, I'm not saying Jimmy Carter was an insurrectionist by any means, but before you even had a Southerner elected. So not only was it not absurd, but their framework and approach was successful. It was very successful. And when you look at the actual language, look, if you look at the structure of the text, it is harmonious. It was very carefully drafted, and every indicator points towards excluding the presidency and the president. Officer of the United States is used in 4 different contexts of the United States Constitution, every one of them which excludes, properly viewed, the president. The appointment clause, of course, there's been a lot of discussion on.
And so fair enough. So what is it does also refer to repeatedly the office of the president and the like.
Office under the United States, officer of the United States.
But when it talks about the president,
Yes,
it describes that as an office.
Right.
So the president is an officer. What is the president an officer of?
So the, if I can find my notes quick enough, the analysis that has been found is that the president is an officer of, to the extent we have that concept, of the Constitution. So an office under the United States is one created by the United States government. An officer of the United States is one that serves the United States government. And there's precedent that says, look, senators, representatives, and the presidency, president, they are the government. That's sort of the analysis, the distinction. And look, opposing counsel pointed to the emoluments clause as absurd. How could you possibly believe a president would not be part of the emoluments clause? Well, I would suggest you walk into Mount Vernon, and you will see above the fireplace a full-length portrait of King Louis XVI that was given to George Washington by the French government. And no one batted an eye. It was never viewed as a violation of the emoluments clause because no one thought that it applied to George Washington. There's also the key to the Bastille that was given by a representative of the French government.
We've got enough on our hands without emoluments, right? So,
but I wanted to point out the structural point that it's all consistent with the president not being part.
let me just harken back to something that was said by opposing counsel, and that is, maybe we shouldn't be so quick to attribute significance to what the framers did with Article 2, Article 6, given that we're talking about framing and ratification that occurred during the Restoration. So maybe it's part of the puzzle, but is it really all that illuminating when we're talking about 80 years difference, and shouldn't we be looking to other sources given that amount of time?
I think it's very illuminating, Your Honor. I mean, the one thing I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous. Doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution, the original Constitution. The drafters of the 14th Amendment. And there are two oaths. One that clearly applies to the president, and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, people interpret it differently, but that's the language of the Constitution. And my point is this. The drafters of the 14th Amendment said, what oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths. Or they could choose both of them. They chose one and one only. The one that did not include
the one that covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law defining the two.
So can you make the argument that an oath to support is stronger than an oath to preserve, protect, and defend the Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things.
Like preserve, protect, and defend.
It can mean that, but it can mean other things. Or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the logical consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
No, my argument is this. My argument is that the drafters chose specific, and the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate things, but the drafters of the 14th Amendment made a choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency, by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude.
Why?
By choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers, and they did not choose the Article 2, which applies to the president.
And I guess I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis.
I would suggest that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think that the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this were as designed, would prevent anyone in that situation from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, can that be an insurrection? Or is that democratic choice? Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different, and if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, look, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
But the rule of democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, the argument, if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution, and there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used To satisfy the conditions of Section 3, you have to be an office under the United States, you have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. The officer of the United States is used 4 times in the structural Constitution. And each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not going to. I want to let you use your time the way you want to use your time.
So I feel like
Please feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse, and so the counter-argument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, look, this isn't a case, the incitement, and obviously we contest that incitement is part of Engage. Happy to address that as well. But this isn't an instance of sort of joint planning or a joint agreement where President Trump had specific conversations of back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th. That's really what you have to look at. And if you look at January 6th, his speech said, "Go peacefully and patriotically." He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Oh, okay, go for it.
And what he said is, he talked about that he was unhappy with what happened on January 6th. And people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was that use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on, those various iterations are used commonly throughout political discourse. So,
I'm sorry, finish your thought and then I'll jump in.
So the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent. And if other politicians and we included, senators, and President Biden uses the term "fight like hell." It's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said intent in an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying stay peaceful. And he third made a video that said be peaceful and go home. Now,
I want to let you keep going.
now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said be peaceful. But the objective language is saying be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I struggled with as I tried to evaluate this particular piece of it, and that is that are we not dealing with clear error review of the trial court's factual findings about those circumstances? And I realize from your perspective, a lot of those findings were predicated on a report that never should have come into evidence. But setting that to the side for one moment, aren't we, to a large extent, stuck with the trial court's findings findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application? So I'm sort of throwing multiple issues in here, but I don't know that we are in a position to say that there was clear error with respect to her findings of his intent and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened, because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things that happened before January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminent standard. And that is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all.
Although the trial court did, right? I mean, she found specific...
And it's clear error for her doing that.
Okay.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets